So thank you for joining us for the frequently asked questions about healthcare directives. So today we have our speaker is attorney Tiffany Kudrovets. She focuses on the estate planning and on guardianships and conservatorships here at Generations Law Group. She has been with us for over a couple of years now and has been an attorney for more than just a couple of years. And we're just thrilled to have her, and I'm going to let Tiffany take it away.
Thank you, Carol. Hi, everyone. Like Carol said, my name is Tiffany Kudrovets. I'm one of the associate attorneys here. We all do estate planning, and I also do a lot of conservatorships and guardianships. Today, I'm specifically going to be talking to you about frequently asked questions on healthcare directives. So when we do estate planning, and if you come in for an initial consult, or if you sort of doing an overview of what types of documents do I need in an estate plan, a lot of people will think about a will and a trust, and we're hitting on a different side of that, which are healthcare directives. And when you come to us, there are three main documents that we'll talk about related to health that are legal forms. And the first one is a healthcare proxy. And a healthcare proxy is a document that you'll sign that names a person who would be your healthcare agent or your healthcare proxy who can make decisions for you if you can't make them. And a healthcare proxy is unique because it's something that you sign and it's just in waiting. So while you're fully competent, you continue to make your own decisions. You can get input from anyone you need to, your friends, your family, your doctors. But as long as you're fully competent and you can make informed decisions, you're completely on your own in terms of decision making. But what happens if you lose capacity, or if there's an accident, like you're in a car accident, or you're going into surgery? There are some times where your healthcare proxy will be activated in an emergency situation, or it could be activated long-term. For example, if you have advanced dementia and you're no longer making informed decisions, a doctor could activate your healthcare proxy. And what I mean by saying activating is that the doctor would write a letter and say, this is my patient and this is their current health diagnosis. And they essentially can't make informed decisions about their health, weigh the pros and cons of different treatments. They just need support, and somebody else needs to be able to make those decisions on their behalf. And in terms of the document itself, the authority in the healthcare proxy that you would prepare with an attorney like at Generations Law Group is actually very broad. So the document covers everything from routine care to end of life. And so they can help you navigate doctor's appointments, treatment options, end of life care and comfort, basically everything in between. And the healthcare proxy also includes more specific things. Like say you're at home, but you need to go to a rehabilitation facility, or you're in the hospital and you need to be transferred to hospice care. And your healthcare proxy can make all of those decisions on your behalf if that authority is in the healthcare proxy document. It also includes different levels of medication, including antipsychotic medication. And it's personal choice how much you include or don't include, because it's a document that could be tweaked. But your healthcare agent can also make decisions on medication. In terms of how your wishes are communicated, one is that you should communicate your wishes to your healthcare agent so they know exactly what you want to happen, both for routine care, end of life. If you have any moral or religious beliefs related to treatment or medication, if you want to stay at home, for example, and you absolutely don't want to go to a hospice center, or you prefer assisted living over a different facility, all of those types of wishes are things that your agent should know about. And then when your proxy is activated and they're speaking on your behalf, they actually communicate those to doctors and healthcare providers for you. So they would be the ones who would say, they're not just saying like, I think that Carol should do this. They're saying like, Carol wants to do this. Carol's treatment plan should be this, because they already know what you have told them, and that's how they're speaking it. There could be times when you're fully trusting your healthcare agent to speak on your behalf. And so they're doing the best they can based on the information that you've given them. And so they might not be 100% right. You can't predict every scenario, but that's why it's important to do your best to communicate those in writing or out loud before your healthcare proxy is activated. With the healthcare proxy, it can be activated and deactivated over and over again. So when I describe that emergency scenario where there's a car accident and you're unconscious and they're transporting you to the hospital, once you regain capacity, you make your own decisions again. Or if your treatment plan and different medications, the doctors could say, oh, we need to activate this right now. And then you get through that hurdle and you're back making decisions again. So it's a very fluid document. It's also fluid in the sense that you'll name a primary agent who will be your healthcare proxy, who is the person you want to speak on your behalf, but you're also going to name one or two successor agents. And it's possible that you'll have named a primary agent who is not available for some reason, and the doctors or emergency personnel will jump down to the second person on your list, or even third, just depending on urgency and what's happening with the people who you've named. A healthcare proxy is a document that can be changed anytime as long as you have the competency to execute legal documents. So you might name your spouse and an adult child, and say your spouse passes away and that child moves away, but you have another child who lives closer, or your neighbor. So just know that it's something that you can change over time. There's two other documents that we talk about with respect to estate planning. One is a living will. And a living will is not a binding document in Massachusetts. It's a guidance document that has end of life wishes. So this would be in a scenario, say that you had a terminal illness and no reasonable chance of recovery. And it basically says, please don't do extraordinary measures. Like, I don't want to be on a ventilator and be tube fed. You can let me die peacefully. It still includes, please make me comfortable, but it basically says it's okay to let me die peacefully if there's no chance of me living, like regaining the capacity I had before, or my health improving to what it was before. When you sign your living will, again, it's not a binding document, so your healthcare proxy can actually override that decision. The nice thing about that is that your healthcare proxy is someone who's helping you navigate through this, and they know your wishes and they know your entire medical team at that point. And so if they think you have a shot of recovery, or if there's another treatment that hasn't been tried, it gives them that flexibility to say, I still think there's a reasonable chance, and I really want you to try this, as opposed to just saying, okay, I guess that's all. They get to use their judgment at that point in time to do what they think you would have wanted to do. In some states, living wills are binding. So if you have a document from another state, or if you've moved somewhere else, all states have slightly different rules. But just in Massachusetts, it's not binding. The third document that we recommend as an essential healthcare document is the HIPAA authorization and release form. When you go to the doctor's office or the dentist, they always give you paperwork to sign when you're a new patient or annually. And you're signing something that says, I acknowledge that this doctor's office is going to keep everything completely private. There will be no sharing. They have top of the line safety measures. My information is safe here. But we actually are saying in this release form, I understand you have all these rules on privacy, but I want you to be able to talk to these specific people. And the reason that the HIPAA authorization is separate from the healthcare proxy is because there are times when you might want help with decision making or treatment plans or following up from appointments, where you want to designate someone to call and talk to the doctor's office for you. And so if your healthcare proxy is not activated, that agent actually doesn't have any authority to talk to anyone. The HIPAA authorization bridges that gap, so they can call up and they can say, I was at the appointment earlier and you mentioned this, or you said something about the treatment plan and our notes aren't clear. Explain what that means. Or I want to get an update on my loved one. What's going on? With the HIPAA authorization, though, the person can't also say, oh, based on what you told me, this is what I think you should do. HIPAA is purely for information sharing. HIPAA is a good one too, where a lot of people will name their spouse or like one adult child will be on their healthcare proxy, for example, but they have like 3 children, or they have a close sister or a neighbor who takes them to appointments. And it's nice, you don't want to put everyone on the HIPAA authorization and release, but it's a nice way of including more people on that team who can exchange information on your behalf. The next document, we put it on a special slide because this is actually a medical form, not a legal form, but it can become very important for some people. It's called a MOLST form, and MOLST stands for Medical Orders for Life-Sustaining Treatment. Each state has its own MOLST form, and they're very similar, but if you're in Massachusetts, there's a Massachusetts one. And this document is actually something that a patient would sign with their doctor. And it's supposed to come into play when the person is of a certain age, which is not defined at all. So it could be 70, 80, 90, 100. There's no actual definition. And when there's a terminal illness, like an advanced illness where it's very likely that life or death decisions are going to be made and made quickly. And so the MOLST form, I'm going to show you something at the end, an image of it, but I'm not going to ruin the slideshow right now to show you. But the MOLST form is a pink piece of paper. It's two-sided, and it's something that would go on your refrigerator at home, or if you're in a nursing home or a hospital, it's something they'll put on your whiteboard, because these are actual medical orders that go into effect immediately, and there's no discretion in them. And so when you see the form later, you'll see it has CPR, it has artificial nutrition, artificial hydration, it has ventilator, it says transfer me to a hospital. And when you go through that form with your doctor and you choose yes or no, those are actual mandated medical orders with a code that says, like if an ENT comes to your house and they see that, they know exactly what to do. So it's something that's not taken lightly by any means, and it's not something that you would specifically ask your doctor for, because again, it's very person specific and based on your likely outcome, your diagnosis, your age, all of that comes into play. And again, that's a medical form, so you still want to have all of your legal forms so you can have someone supporting you, but the MOLST form is something with your doctor. I put the star by probably in the wrong place, but if the patient is incapacitated or they have a healthcare agent speaking on their behalf, the healthcare agent and the physician can actually work together to draw up this form. So it could be created by the patient if they're able to do so, or it could be created by someone acting on their behalf. So this slide explains the differences between a healthcare proxy and a MOLST form. Again, the first one is that the MOLST form is a medical form you do with your doctor, and the healthcare proxy is a legal document that you would draw up with an attorney. For the MOLST form, I just went through most of this, but some emphasis in terms of the healthcare proxy is that once someone turns 18 years old, a healthcare proxy is very important because there's a very strict cutoff when you become an adult. Whether you're 18 or you're 100 years old, you need that healthcare proxy if you want someone to be able to make decisions for you when you can't. The healthcare proxy has formalities to it, so that's why it's signed by you, and there's 2 witnesses who sign it. You want to have a valid healthcare proxy, just because you want something that doctors and hospitals are going to know was executed correctly in a very intentional document. And the last one, just to point out again, that the MOLST form, it doesn't have anything to do with your legal competency or capacity. As soon as you sign it, those are medical orders. Whereas the healthcare proxy is something you draw up while you have full legal capacity to execute documents, and it's activated later. I've definitely experienced some of that on my own, and I've heard of clients who have had people say, they're very strong reactions, and some people take it very seriously, and some people want to make it a joke, some people want to ignore it altogether. But it's important that you will have the conversations with someone. Quite often clients will say, oh, if I name someone in my documents, do I have to tell them? And I say, well, technically you don't have to tell them, but it would be a really good idea if you choose people who you can communicate with and let them know and make sure they're receptive to it ahead of time. The main thing is this first bullet point here. Make sure that the person that you choose for healthcare decisions is someone who will follow your wishes, even if it's not the same as theirs. And sometimes that just means they have to just sort of be able to separate themselves and remove the emotion from it and just make a very factual decision. Okay, this is what the doctors are saying. This is what you told me, and this is what sounds best based on all of that. And you want someone who's going to advocate for you, someone who's going to go in and speak up to the doctor, raise all the concerns. They could be the person taking notes or not, but you want someone who's going to be able to pay attention and put it all together and make sure that your wishes are conveyed to anyone who's taking care of you. A lot of times people, this is a little bit of a branch from this, but in terms of healthcare proxies and powers of attorney, which have to do with financial legal matters, people will just pick one kid for one and one kid for the other if they have adult children. And I just think that is just not a great idea. And they say, oh, we want to spread out the work. And I say, well, they're both jobs. And so I understand that. You want to make sure that you're picking someone who you trust, who's going to listen to you, who's going to do a good job. And that might be the same person for across all of the roles. And there might be one friend or family member better suited for one thing than another. I just encourage you to make a very intentional decision when you're choosing your healthcare proxy because there's so much riding on it. Can you choose more than one person is a very common question. And I told you before that there's a hierarchy where you name a primary agent and then you'll name a backup or two. I think across the board, it is the best idea to name one person. That one person can talk to everyone, and that's part of what you would communicate to them. But one person should be the ultimate decision maker. It's more simple for you to have one person. It's more simple for the doctors to know. Like I have named Carol. Carol's the ultimate decision maker for me. If you name a spouse and a child, or you name two of your adult children, what happens if they disagree? Or what happens if one decides and the other doesn't like it so much? There's just a lot riding on it, and you want one person to really be your main advocate in speaking on your behalf. It can get messy when there's more than one who's at the same level of decision making. The people you name in your HIPAA authorization and release form cannot make any decisions. And so if your healthcare proxy is activated, that person's making decisions and has full access to information. At the same time, say you had two other people on your HIPAA authorization, those people could still have communications and talk, but they're not going to make any decisions. I talked a lot about communication so far, and the way that your healthcare proxy knows your wishes is truly communicating. Talk about it, write it down, take them with you to appointments if they can go. You really want them to know both your health history and not just like surgeries and allergies, but anything, any family health history, anything you're on the lookout for, anything you're being monitored for. You want them to have a framework for moving forward in decision making. And it's something that might evolve over time, because when you're younger, you might say, I want you to explore more treatments. I want you to be more aggressive on this. As when you're older, you might say, you know what, try, do your best. I want to be comfortable. I don't want to do anything that's too out there. But it may change over time depending on how old you are. The discussion should also talk about not just what happens now, but what happens later, your after wishes. Your healthcare proxy may not be your successor trustee or your personal representative in a will, but it's helpful if they know, what do I want to happen? Are you an organ donor? If you're an organ donor, do you have any specific wishes about science or education or something else? And even if they're not the ones ultimately making decisions, or if they're working with someone else, it's very helpful if they have a very comprehensive view of what's going on. I see there's a chat, Carol. Is it a question that I could answer now?
It is, you can make it okay for the proxy to talk with others, right?
Yeah, so your primary healthcare proxy can literally talk to anyone. They can talk to any doctor, any medical professional. They can talk to any family members, any friends. And actually, it's part of the communication. I'll show you a workbook that we have at the end also. If there's anyone you don't want your healthcare proxy talking to, like you have an estranged relative or someone who's nosy or just someone you just don't want part of it, you can tell them, talk to anyone, or you can be specific and say, please don't talk to these people. I don't want this information shared. So you can set rules when you're telling them your wishes. You can tell them exactly what they should or shouldn't do for you. In terms of what documents you should give to whom, you should absolutely give your primary healthcare proxy, and I think your backup, a copy of your healthcare proxy form, your HIPAA authorization, and your living will, because those documents are very comprehensive legal framework for what they can do and what they can't do. If there's something that's not in your document, like for example, antipsychotic medication, if that's not in your healthcare proxy form, they can't do that. And there's a hurdle to overcome to say they should be able to do it. So that's why I say if you give them the documents, they'll know what's in there or what's not in there. The MOLS form, if you have one, is also good for your family to have a copy of, just because they can't change that form necessarily, but it's good for them to know if someone comes in, these are the actual orders. In terms of your doctors, what I think is very helpful, I would give them a copy of your healthcare proxy and your HIPAA authorization and release. Those two forms are important for doctors to have. And if you have like My Epic or Reliant or whatever program you use for your doctors or any hospitals you go to, you can upload those two documents on the portal. If you're having surgery or just going in for annual checkups, you can bring those documents with you. You could give them your living will. It's really a personal decision, because the living will is not a binding document and there's so much discretion for your healthcare proxy. I think just having the healthcare agent know that information and have it with them, like in their mind or the document if there's a decision to be made. I don't think your doctors need the living will. If you gave it to them, there's no harm in doing it. It's just that we're still relying on the healthcare agent. Anyone I mentioned this before, but an updated list of basically medical status. You want your healthcare proxy to know what's going on, and say you are allergic to some medication, like you can't have penicillin. If you're making a really quick snap judgment on the phone talking to a doctor, you hope they have the full medical history there, but it's something where you can just snap say, wait, they have an allergy to this, or they can't do this. So that's why we want your healthcare proxy to have literally everything. And it's also helpful for your healthcare agent to know not just your primary care doctor, but if you have any specialists, any routine screenings, like if you have your annual mammogram or if you had MRIs, any files you have, any records you can have, just keep them in one place so that they're not searching for that information later. So if you have a MOLS form, it's a medical form that your doctor would say that you need to have. And the MOLS form is completely optional. Okay, if you have a healthcare proxy, that's a legal form that's saying someone can make decisions for you. The doctor does not have to have a MOLS to make any decisions. They can rely on the healthcare proxy 100%. But in times of life or death, where just like your illness is so terminal and you're at that age where they just think we have life or death decisions that need to be made immediately, that's when the MOLS would come into play. So they can rely on the healthcare agent. I'm going to give you a scenario that happened to one of my clients. It was someone who was under guardianship and conservatorship. And what happened is that there was a healthcare proxy in place and he was living in a rehabilitation facility with 24/7 care. What happened is that every time he got ill, they took him to the hospital. They gave him CPR, they fixed him back up basically, and then they sent him back to the rehab facility. And it happened over and over and over again. And the healthcare proxy couldn't do anything because the facility was saying, well, there's not a do not resuscitate, there's not a MOLS form, there's nothing that we can do. And basically, it was very sad. He was just in this cycle of going back and forth. And when she was able to meet as the guardian of this man, when she was able to meet with the doctors and get a MOLS form signed and give it to the facility, that stopped the back and forth. And I think it was a comfort to her as the spouse instead of watching him go through this struggle, because he wasn't getting any better. So when a MOLST applies, when a doctor recommends it, it's not a light decision at all. But it's something that can stop that cycle of someone who's just going in and out of very severe treatment for a terminal illness. But a healthcare proxy is fine. And a valid healthcare proxy includes end-of-life decision-making with it. It's all situation specific. But the most is just a very firm, like, these are absolute guidelines on what must happen. So there's clarity for the doctor or the hospital or the EMTs who arrive by ambulance at a house what to do. So that's why you might have both of them. But that's a long-winded answer. But I just want people, some people say, should I get a MOLST form? And I say, no, you shouldn't just get a MOLST form. Like, wait until the situation warrants it. How could I forget? This is, like I mentioned in the beginning, I do a lot of conservatorships and guardianships here. And if you don't have a healthcare proxy, it can lead to a guardianship. And there's actually going to be another webinar in a couple weeks about guardianships and conservatorships. I actually just sort of mentioned some of this. The healthcare proxy document, if you have it, and it includes these powers, the healthcare agent can make end-of-life decisions. They could authorize antipsychotic medication treatment. They can put you in a nursing home, a rehabilitation facility, hospice. They can move you across state lines if that's what makes sense for your care. They basically have a really broad authority to help you with those medical decisions. They can't apply for government benefits like Mass Health, but most likely, especially if you work with us, you would have both a healthcare proxy and a durable power of attorney. And so the power of attorney could apply for benefits. The healthcare proxy would still be taking care of the medical decisions. If you don't have a healthcare proxy, or you have one that's insufficient, meaning say you need to be transferred to a facility, but there's no specific authorization for that. Or say you need antipsychotic treatment, but it's not in your healthcare proxy, then someone would apply for a guardianship. And guardianship is a court proceeding. It's getting to be a little longer now, but it generally takes about 2 to 3 months. You can get a temporary guardianship if there's an emergency, which is still not super duper fast, but it's better. But in order to make any of these decisions that a healthcare proxy would make, you have to get the court to grant those things. And in order to do so, like with antipsychotics, if you've done any reading about guardianships, it's a Rogers order. And Rogers is a court case that involves someone who was being treated. But it basically says there's someone who's going to monitor antipsychotic medication and its extra level of scrutiny. In order to move someone to a different facility, you have to get specific permission for a guardian to do that. Guardians have to do a care plan right away once they're named guardian, and they have to do an annual plan. And so to the extent you can have a guardianship, a healthcare proxy that's thorough, and I like to call them beautiful documents. If you can have a really beautiful healthcare proxy that has everything we'd like to see in it, most likely you can avoid the need for guardianship. Guardianship is very hard on the person who's helping you. At that point, the court would deem you incapacitated, and there'd be a medical certificate for that. You don't want to be in this blue column. It's a very emotional, long process for the person who's helping you. This was more like a comment and question about a primary care physician initiated a MOLST form a few years ago when there wasn't a medical situation, and there is not one now. And can we tell them to destroy it? You can absolutely tell the doctor to destroy it. You can say, I don't want this right now. I want to rely fully on my healthcare agent right now. If it comes up later that this is something we should do, we will. And especially since you have the other healthcare documents. And you could ask the doctor, why did you recommend the most form for me back then? It doesn't seem like it applies. And they might have some reason for it. But you could tell them to destroy it and rely on your other documents. This is the most form. So this one has this disclaimer at the top: every patient should receive full attention to comfort, because the most form and the living will are not about making someone feel bad and live through pain and suffer. It's all about comfort, but not unintentionally prolonging someone's life when there's not a chance that they're going to recover. But again, it has CPR and ventilation. Transfer to hospital. It has the patient signing or their healthcare agent, and you sign in the capacity that you're doing it. So if you're their guardian or healthcare agent, you indicate that. The clinician signs it. On page 2, there's more specific things. These are just all life-sustaining type measures, and if you want them or not. And also, if you have a most form, you might look and see, you might have undecided on there. They're all different. So this, again, it's a pink form that's double-sided that you would have. Every state has a different one. So if you move out of Massachusetts, like if you were in Rhode Island, you'd want to get the one that says Rhode Island medical orders, just in case the rules are different in the other state. The other
So Tiffany, do all these forms last forever, or do they need to be redone at any point in time, even if you're not changing anything?
So with the healthcare documents, there's no expiration date to the healthcare proxy, HIPAA, or living will, as long as the information in them is good and you're fine. And say you name a primary agent and that person passes away, but you have a backup, nothing needs to be done. You don't need to update the document as long as you have the backup. There are some documents. In general, we recommend that you look at your estate plan every, say, 3 to 5 years. If there's any big changes, like if, say, you've named agents and they died, or you've named people who've moved away, or there's family harmony isn't what it used to be, like those are good reasons to change your documents now. But for medical orders, if it's just the passage of time, you should be fine. Again, if you've done a really thorough healthcare proxy with Generations Law Group or another good attorney, your documents should have everything you need in them. So mostly what you're checking is just to make sure everything looks good. A lot of times people will move or change their phone numbers. My recommendation to you is not to write on if you have your original documents, like if we're not holding them, please don't write on your original documents, even to fix a phone number. I would just add like a sticky note, or if it's a copy, write on it, just because you want your original documents preserved, because it's better to have an original document. Even if everything is wrong, we can show that to the court for guardianship. We just want to preserve the integrity of original documents. But no, I think the healthcare forms, they don't actually expire. I wanted to show one more thing before we go, and I'm happy to answer more questions at the end. On our website, if you go to generationslawgroup.com, if you click on resources, the ebook section is very helpful. If you click on ebooks and you scroll down, there's a ton of books. A lot of what I discussed today would be in estate planning essentials, and it would describe the documents. But what I wanted to point out was life conversations with your important people. Sometimes the conversations are hard, and it's easier just to say, you know what, we're just going to go through it. It's just a workbook, just a little exercise. We're going to get to know each other. But this has information on everything, not just healthcare decisions, but it's a really nice starting point for the conversations, and it gives you an idea of the full range of everything that you should talk about. The ones important people, aging parents, and adult children are actually all very similar, just the wording is tweaked. We have printed copies in our offices, so if you ever want to pick one up, you can email us or call us and we'll put together a little packet for you of information.
I'd like to just make a quick question if I could.
Sure.
My question is primarily, first off, I'm going to just tell you that I'm not in Mass. I'm in Rhode Island. I'm 60 years old. I'm a solo ager who really doesn't have much family. That I was wondering, like, who do you appoint when you don't have anybody to appoint was the advice I was looking for. But I didn't know if you can give me any advice around that kind of an issue.
We could put you in touch with a Rhode Island attorney. I know someone who's very good. What you could do, and I think an attorney could help you find someone, is look for a care manager or an aging advocate. There are professionals out there who act as guardians and conservators and advocates who could help you. But there are professionals who can be hired to help manage your care and take care. Essentially, they can be your healthcare proxy. It's called, what's for solo agers, but an attorney fiduciary program. And that's for a client who does documents with us but doesn't know who to name. Or sometimes they do. They're like, I have all these people, but actually I trust you, or I want you, or I don't want them to worry about it. And in that program, there's some fees associated with it. There's a lot of benefits to the program. But one of the things we do is have an annual mandatory meeting where we sit down with you and we get to know you really, really well. And it depends on if we're your power of attorney or healthcare proxy or both. I met with someone last week and she's like, I think you know me better than almost everyone in my life right now. So it's not something that we take lightly, but it's something where we expect you to be fully open with us in full confidence. If you need that option, I wouldn't think of us as a default. I mean, think of us as your greatest advocate. But we do have a very thorough program for that.
And
And
to
you can, if your family members don't
Yeah.
want to do it, that's okay. You can choose a friend who's a solo ager. You could also, depending on, I think it's nice to have a backup, but if you have a primary agent, your primary agent can act, or that someone who's serving can delegate. Say that you name a solo ager friend who actually has no idea what to do but cares about you and wants to help. They can be authorized to hire a geriatric care manager or to hire an accountant if they're your power of attorney. Nobody has to do any of these things alone. And so I think a friend is a perfect person. And I think having a document naming someone is better than having no document at all, even if there's no backups. Just do the best you can when you can. And then if you end up with other friends or if we can be your backup. I don't want anyone to not have a healthcare proxy power of attorney, because when I go to court for conservatorship and guardianship, but I know how it feels to be sitting next to someone in this incredibly stressful, expensive process who's shaking before seeing the judge. And I think if only these documents had been done, that's my pep talk.
All right, everybody, have a great afternoon. And if you need us, give us a call or shoot us an email.
Thank you all.
Thanks, everybody.